Okay, I think he's here. Um, Good evening, everyone, and welcome to the Leaflet's Constitution Day talk. Let me begin by reminding everyone that this session is being recorded. Trolling or disrespect of any kind will result in the removal of the participant involved. Mr. Venkatesan will be commencing the session. As many of you may know, he's a veteran legal journalist and took over as the editor of the Leaflet recently. He has close to 30 years of experience as a journalist, including 27 years at Frontline. Since his retirement from Frontline as its senior associate editor in 2020, he has been contributing to The Wire as its legal editor on contemporary legal issues. For The Wire, he authored the multi-part series on Justice Arun Mishra's tenure in the Supreme Court and on the basic structure doctrine, both of which received widespread praise from all quarters. He has authored a book, Constitutional Conundrums, Challenges to India's Democratic Process, published by LexisNexis. I'm now going to hand the platform over to Mr. Venkatesan to introduce the leaflet.
Good evening, everyone. It gives me great pleasure to, join in this Constitution Day function organized by the Leaflet. As you all know, as Gauri told, I joined Leaflet as the editor only earlier this month, but I have been an ardent reader of the Leaflet right from the beginning. As many of you may know, the Leaflet was started in May 2018. On the last working day of Justice Chalameshwar, there was a farewell function in New Delhi to him, and on that day, friends and well-wishers of Indra Ma'am and Anand Grover, they all came together to facilitate Justice Chalameshwar, as also to think about creating a broader platform for like-minded people like us who are interested in civil liberties to come together to share our experience and also the values, the constitutional values, which have been so dear to us all these years. And why many of us wonder why the term leaflet was chosen for a website like us. As the statement of purpose, which one can find, any reader can find on the Leaflet website, it says that Leaflet was chosen because both for personal reasons as well as for linguistic reasons. In the sense, earlier we were all using Leaflet as a mode of organizing, mobilizing public opinion. Now the medium has changed. In the sense, we all now use Twitter, Facebook, and whatnot. But Leaflet has always been part of our, for many of our senior people, had always been part of our work ethic. In the sense, it helped us to keep in touch with others, to mobilize, to protest, and organize meetings, and so on and so forth. So in order to, go back to the roots of our public engagement, the term was chosen, and it was wisely chosen in the sense it helps us to remind ourselves the non kind of cultural and as well as political vibration that this very term evokes in all of us. Well. As a platform for political and legal opinion, what does Leaflet stands for? As the very website proudly proclaims, Constitution first. So we all know that Constitution first, in the sense, the principles, the preamble, which always guides us in our day-to-day life, and also interpreting the various constitutional provisions. So that is always very dear to us, and in all our reportage. And also, when we carry, when our website carries news and analysis and interpretations of contemporary events, the emphasis has always been on the constitutional principles, the first principles, so to say. So when we are in the midst of a huge political and social, I won't say turmoil, a sort of crisis, contemporary crisis, in the sense the very principles of the Constitution are being questioned day in and day out in almost every walks of life, be it secularism, freedom of speech, and activism. So we are all under attack all the time, not only from the executive, but from many extra constitutional actors. So it has been our experience that the mainstream media is not enough to question, to remind ourselves the values, the constitutional principles that have been the guiding spirit of our times. So that is why the leaflet, aims to fill the gaps in our contemporary lives. So what are the gaps which we find as far as the media is concerned? So we all know that the electronic medium, how far it has been functioning without any freedom and accountability. So that that is besides the point, in the sense, even the mainstream media, the well-established newspapers and the websites, we find that there is a reluctance to seriously engage with contemporary issues. Not only in terms of breaking news and superficial analysis, which we find in most of the newspapers and websites, but there is a serious longing among the readers for an in-depth and long form kind of journalism, which we're missing in our contemporary times. So Leaflet aims to fill that gap and provide in-depth reporting as well as long format journalism wherever it is possible. So that is why when we say that we are not in competition with breaking news websites, so the idea is to engage seriously with contemporary issues where there is scope for asking questions which others don't ask. We will ask. We'll not only ask, but we will try to provide answers. So, friends, this has been the philosophical underpinnings and the ideological background of the leaflet, which have been guiding us all these years. And I hope to take it forward as a new editor. And I will welcome you all for this serious discussion. And I welcome the chief guest, Justice Justice Gautam Patel, and also the eminent panelist, Justice Patel, who have been with us, and they will, give us their own interpretations of the contemporary issues, as well as offer their perspectives, which will be of immensely helpful to us to understand the contemporary events. Thank you so much. And as you take part in this Constitution Day function, I request all of you to subscribe as well as contribute articles to the leaflet to enrich our public discourse. Thank you so much.
Thank you, Mr. Venkatesan. Senior Advocate Darius Khambata is also here with us today. No stranger to anyone who has spent any time at the Bombay High Court. He has a large and varied practice involving constitutional, commercial, securities, and administrative law, and has advised on several significant domestic and international commercial arbitrations. He has previously been the Advocate General of Maharashtra and Additional Solicitor General of India. He'll be sharing his insights with us and introducing us to our other two speakers, Justice Gautam Patel and Justice Madan Lokur. Welcome, sir, and thank you so much for joining us.
Thank you. It's the first time an introducer has been introduced. I'm largely here to introduce the speakers of the day and, of course, the day itself. And so, honorable judges, Justice Lokur, Justice Patel, and others, and friends. Constitution Day is one of the most important dates in the calendar of our country, for it is the day on which the Constituent Assembly, after intensive and recorded debate of 3 years, adopted the Constitution. It is a magnificent Constitution by any standards. And it's the amendments have somehow diluted its cost to some extent, but it still remains a magnificent structure and the embodiment of our constitutional democracy. Because a democracy does not consist, as we know, of only holding of elections. It is one essential component, no doubt, but constitutional democracy is far more than that. And we cannot but remember today Dr. B.R. Ambedkar, the chairman of the drafting committee and a member of the Bombay Bar, who really oversaw and put together this crafting of this great document for the future and for the future of our country. The Constitution, as you know, inculcates respect for fundamental rights, equality, liberties, freedom of speech. It inculcates respect for institutions, independence of institutions, separation of powers, a respect for parliament, which is the crucible of democracy, and for the rule of law, and for so many other things. But I believe it constitutes a document that also can and must unify us. There is far too much discord in our country. We have not yet learned the art of disagreeing agreeably. And I think the Constitution gives us a template or a matrix within which we can learn to do that and respect each other's views. It's a constant struggle, whichever side you're on, whatever perspective you have. For, as Felix Frankfurter had said, democracy is a beckoning goal. It's not a safe harbor. It's constant in the making. And so when we are to hear today of this concept of the idea of India, I ask myself, what is the idea of India? Is it written down somewhere? Who envisaged it? Where do we find it? Is it in a document? Is it historical? Is it ancient? Is it territorial? Is it religious? Is it geographical? What is this idea of India? And doesn't the idea of India ultimately depend on from what perspective you are viewing India from? True, you can see it that way. But I believe that the idea of India necessarily must start and is reposed in our Constitution. That is what we have to be truly grateful to our founding fathers for, because they reposed in the Constitution very broadly the idea of India. They summarized it in the preamble, and then they fleshed it out in the other provisions of the Constitution. Now, of course, these provisions are not stagnant. They are not rigid. They are elastic concepts. They're concepts that change with modernity and with times. And our Supreme Court is the guardian of those concepts. And so the idea of India can be found not only in the Constitution, it can be found in judgments of the Supreme Court. And of course, it's not a straight line forward. There are zigs and zags. There are different curves and turns. But ultimately, I believe constitutional law encapsulates the idea of India. It's something we have to very jealously protect and guard. Now, to talk to us today, we have two very, very eminent persons. One is, of course, Justice Madan Lokur. Neither of these two persons require any introduction, but it falls to my lot to introduce them. And so I shall try my best. Justice Lokur started his practice, of course, before the Delhi High Court. He was the Additional Solicitor General of India in 1998, and then he was appointed as a judge of the Delhi High Court in 1999. We had all heard about him then. He was an active judge of the Delhi High Court, and ultimately went as Chief Justice of Guwahati and Chief Justice of the High Court of Andhra Pradesh. He reached the Supreme Court in 2012 and retired in 2018. It was a 6-year tenure, but it was an impactful tenure. He did so much as a sitting judge of the Supreme Court. As a member of the Mediation and Conciliation Project Committee from its inception and later as chairperson, he galvanized the whole concept of mediation and later computerization of all courts in India. This is a concept that's so important to us today, especially after the pandemic or during the pandemic. But he also had civil liberties at the core of his personality. So he took active roles as a one-man committee earlier to suggest measures and improvements for juvenile justice care. And he was a very activist judge, even in the Delhi High Court, as I mentioned. His bench in the Supreme Court was popularly known as the social justice bench. There are so many judgments. So today is not the day to give you a list of all his judgments, but each of his judgments showed a desire to advance the law, not just to merely apply it, but to advance it, whether it be social ostracism and harassment of victims of rape and sexual offenses, whether it be the environment, whether it be election practices and questions of disqualification. And he's held, for example, that politicians addressing electorates on religious, caste, and language grounds, those could qualify as corrupt practices. In all these measures, he advanced the law, he pushed it forward, and we are ever grateful for that. Now, he has not rested on his laurels after retirement. He was immediately appointed judge of the Supreme Court of Fiji. Good luck, we are lucky to have him. But he is thrown himself into the social and economic politic of our country. He has an interest in alternative dispute resolution. He's a very active and effective arbitrator. He's concerned with child rights, legal aid, judicial reform, judicial education, a myriad social justice issues. So I really don't know how to stop and when to stop, but I suppose I have to stop. And we are very, very fortunate to have him here and support so many great causes. He's a courageous judge. He speaks and writes freely, frankly, and courageously. And we are truly grateful to him. He has truly improved our country and the value of life in our country. God bless Justice Lokul. Thank you for being here. I turn with that to the speaker of the day, Justice Patel. We've known Justice Patel, of course, for years and years. In fact, I remember he gave me my first company law drafting brief. He will remember that matter. He started his practice in the year 1987 in a very activist chambers, chambers of Sohini Nanavati, who, though she was a matrimonial lawyer, was a very activist lawyer concerned with social causes, and she could not suffer injustice lightly. And her husband, D.H. Nanavati, who was, of course, the lawyer for so many environmental issues, especially of the BEAG in those days. And Justice Patel himself threw himself with great gusto into environmental issues from the very early years or months of his practice. So the Sanjay Gandhi National Park, protection of mangroves, town planning issues, mill lands was his great masterpiece in the early part of this century, protection of open spaces. He, as we know, is a Renaissance man. I mean, his talents and likes are absolutely legendary. He loves history, art, literature, law, music, photography, fountain pens. He has a fantastic stationery collection. Cinema. He's the most adept at computers and technology. I remember years ago when my wife had some problem with our computer. I said, please call him up. And when I came home, she said, my God, I've never seen anything like this. He didn't even see what the problem was. He said, what's showing on your screen? Okay, do this, do that, do this, do that, do that. And the problem was solved. So he's really a man for all seasons and of many qualities. But we have seen recently his qualities as a judge. We've seen not only the excellent language in which he crafts his judgment. I mean, each one is a pleasure to read, starting from his suspicious drinking of a cup of tea and so many others. And through his judgments comes out his passions. Free speech is very important. In one matter he wrote, when he talking of in a defamation action against the media, he wrote, we forget that but for them, the many uncomfortable questions that must be asked of those in authority and those with sheer muscle power of money would forever go unasked and unanswered. We forget that it is these persons who we are wont to mock, who are truly the watchdogs of our body politic, the voice of our collective conscience, the sentinels on our ramparts. This is the purple prose, but with a lot of depth and meaning to it. He's given several public lectures, and he has shown himself to be a deep thinker, a philosopher, and it comes through in all his lectures, and I have no doubt it will come through today when he speaks to us of the idea of India. Again, there are so many things I would want to say about him. He's a treasure to us. He's been an invaluable asset on our court. And I think ultimately his contribution to freedom of speech law, to pure commercial law issues. There's so many commercial law judgments he's given. I've been party to some of them in the sense of appearing before him. I've read many others, wealth of those. But I think his true métier is environmental law. And I end with a beautiful quotation which he gave sitting on the Goa bench of the Bombay High Court when he was speaking of a vessel and a grounded casino ship which was affecting Miramar Beach. He says, casinos will come and go. They are replaceable. Our beaches are not. The most terrible judgment of all is the judgment of history. And history will judge us all, not by the way we care for things we can replace, but how we protect the things we cannot. Therefore, our beaches and rivers first, casinos later. Wonderful. I mean, this is absolutely correct. In a few pithy sentences, he really encapsulated the idea. So no more from me. I don't want to stand between you and the speakers, but I just want to thank both of them for gracing this occasion. Thank you.
Thank you, sir. That was actually really wonderful to listen to. I'd like to now welcome Justice Patel to share his insights on today's topic of discourse, undermining the idea of India, which way forward?
Thank you. Good evening. It is a privilege to be here, and today especially. I must thank Indira, Anand, and the remarkable online journal, The Leaflet, for thinking of me for this talk today. From Indira and Anand, it was not so much an invitation as a mandibus, but one I gladly obeyed. For I have always held both of them in the highest regard. Over the years, they have been uncompromising and steadfast in their pursuit of justice. In their courage and resilience, they are the indomitable ones in occupied Gaul. What their magic potion is, I do not know, but may the sky never fall on their heads. And thank you to Darius for that splendid introduction, more than a trifle over the top, and I trust you do not believe that flattery will get you a priority listing on Monday. Darius and I go back nearly 4 decades to the time he returned from Harvard, all bright-eyed and bushy-tailed. As he said, I sent him his first drafting brief. I know he will never forget it. There was another that was utterly traumatic, bristling with every conceivable legal argument against our clients. A lesser lawyer might have been emotionally scarred for life by that, but not he. And so sometimes I delude myself that I had a hand in making him what he is today, one of the finest lawyers in the country. He is right, unsurprisingly, about the importance and vitality of our Constitution and of the work of Dr. B.R. Ambedkar. Someday, on this day, in the years ahead, I hope I get a chance to speak about that titanic figure and his hand in determining the trajectory of post-independent India. Listen to this. India 2047. 15th August 2047. 100 years since independence. A land where the ancient patterns and rhythms of life are still unchanged. Small villages, dust, parched, cracked earth. But also a land of super advanced high-tech, artificial intelligence, robots, nanotech. India is fractured, balkanized into smaller regional states. Awadh, Bharat, Bangla. Something is wrong. A super advanced flying machine, a sort of armed helicopter aircraft hybrid, sets down in a dry riverbed. The Ganga is almost entirely dry now. There is no water. The states are desperate. Natural water systems are being modified. Glaciers forcibly melted. There is even a proposal to tow an iceberg into the Bay of Bengal. This is also the center of a high-tech universe. Artificial intelligences, or AIs, have personas. The law now bans AIs that imitate humans, ones that pass the Turing test. They are hunted down and destroyed by a dedicated force called the Krishna Corps. But lower level AIs are everywhere. A long-running television show, or TV soapy, called Town and Country, has a cast entirely of these AIs. And on the nightly television news, experts appear simultaneously on multiple channels, all live. No, this is not the product of my fevered imagination. It is the backdrop of River of Gods, a 2004 award-winning science fiction novel by Ian MacDonald. I chanced upon it about that time in a small bookshop in Kanpur. I was there on work. I don't imagine anyone goes to Kanpur for pleasure. It was some strange hearing before a local government satrap in charge of company affairs. The copy I bought from a local bookstore was a large format paperback, a thick book with a weirdly lurid cover, a picture of a blue multi-armed goddess and of Ganesha, the kind you see sold by street vendors. The book is nearly 20 years old, but the time it speaks of is not far away, no more than about a quarter century. And some of what it describes, in imagination and in fiction, is already happening. The most terrifying part of the book's context is its calm prophecy that India, as we know it today, and as we have known it since 1947, is doomed. It cannot last. It will splinter. States will form and they will go to war with each other, and they will war over water. We may dismiss this as nonsensical science fiction, the stuff of overwrought fantasy. But it seems to me to nail down something critical to our conceptualization of who we are and who our founding fathers meant or wanted us to be. Beyond an arid description of territorial and geographical boundaries, what is India? It seems almost incredible that this enormous landmass, over one-third the size of the United States and of the EU, with over 17% of the world's population, but without a common language, ethos, culture, regional history, or practice, should even exist as a single political or national unity. India is an improbability. By any measure of logic or reason, it just should not be, not in this form. And yet it does. And we take its continued existence for granted. That is a mistake. India is different things to different people. It is no one thing to everyone. People have very different ideas about what it means to be Indian and what India is to them. But there is really only one idea of India, and it is this idea that is the glue that keeps it what it is. This is the constitutional idea of India. Even here, people disagree. Some speak of the idea of India and link it to the preamble to our constitution or to part 3, the fundamental rights. Discussions and debates seldom go beyond the deployment of the usual tropes: liberty, freedom, fairness, justice, equality, secularism, socialism, and so on to the end of the chapter. Yes, each is crucial, each is fundamental, but they are still all components that build on something even more fundamental. I mentioned glue, but think instead of an architectural exoskeleton, the outermost structure. Where do we find this? It is not, I argue, in part 3, though that is, we are told, the basic structure of the Constitution. If we were to look in the Constitution for the idea of India, we should, I believe, find it in an article that is seldom discussed or addressed, and that is Article 1. India, that is Bharat, it says, shall be a union of states. Everything in the Constitution flows from this concept, one often described as federalism of a particularly subcontinental stripe. This has to be the idea of India, for without it, India cannot exist. What it tells us in this incredibly compact sentence, freighted with meaning and implication, is that while we may differ from state to state and region to region, all of us are one. Think of it now as a patchwork quilt, colorful, varied, apparently disordered, cheerfully and delightfully different, and yet all stitched together. And consider what happens if we abandon or lose this conceptualization, this idea of India. We are in the world of Ian MacDonald's River of Gods. Within this tapestry or quilt, there are unifying threads that keep it from being tattered or falling apart. These are our fundamental rights, and they do not distinguish between the Union and its component states. The fundamental rights in Part 3 of the Constitution therefore hold together this constitutional notion of India being a union of states. Article 1, therefore, sets the stage for everything that follows. In particular, it leads inexorably to parts 5 and 6 of the Constitution, again, not much in the public eye. These parts deal with the Union and the states, and within each of these parts, there is a provision that uniquely informs this constitutional idea of India. The provision is that the governments at both the center and the state have, well, to put it bluntly, a limited shelf life. By governments, I mean, of course, the Lok Sabha or House of the People and the legislative assemblies. This means that every 5 years, the government must seek a mandate for continuance, and it must seek it from the electorate. This concept of time-limited governance is critical because it necessarily informs our rights and our fundamental rights. As we shall presently see, these concepts of governments at both center and state, of India being a union of states, and of governments having a time-limited or defined period of existence, are precisely the concern that worry all dispensations. It is this that every dispensation seeks to conquer or to subvert. Allowing it to happen would undermine the idea of India. It was not always like this. In fact, it was never like this. A broad view of our history shows us something quite different. For millennia, we have had rulers, external and internal. They have controlled and ruled territories vastly different in size and topography. Some may have recognized regional or local political identities, but these were always in the nature of subservience and fealty to a stronger central power. This concept of self-determination, or of the people choosing who would govern, and of them being given the right and the duty to make that choice, did not exist in our history, at least not on this scale, nor in this form, until 1947. Actually, until 26th November 1949, 72 years ago, when our Constituent Assembly formally adopted our Constitution. The two concepts, therefore, of a center-state structure and of periodic elections of government at both levels are a radical departure from anything that went before in the history of the subcontinent. This was, therefore, from the framers of our Constitution, a gigantic leap of faith. It involved putting in the hands of this cacophonous, bickering, amorphous, disparate, and ununified mass of humanity a truly fearsome power and a freedom of untold and undefinable dimensions, the power of choice and the freedom to choose by whom we wish to be governed. Madhav Khosla's India's Founding Moment, a book with the delightful subtitle, the constitution of a most surprising democracy, speaks precisely of this breakthrough conceptualization by the framers of our constitution. They knew, he says provocatively, that India's people would need to learn the ways of citizenship. My point precisely when I say that we had no experience of it at all before. But that tutelage was not to be of master and pupil, the colonial British grandly explaining suffrage to the local natives. Instead, our framers gave us the whole package. They threw us into the deep end of the pool. They expected us to swim, not sink. And they did this, heaving universal suffrage or franchise at us in a land of abject poverty, staggering illiteracy, hidebound by the most archaic traditions, and socially fissiparous. Rohit Day, assistant professor of history at Yale University, says this in his sharp work, A People's Constitution, the everyday life of law in the Indian Republic. The institution of adult suffrage and the institutionalization of the social revolution are the markers of radical change in the Indian Constitution. The institutionalization of universal franchise was a revolutionary act in a deeply hierarchical society, especially when the franchise had only recently been extended to women, people of color, and working class men in various mature Western democracies. Franchise without restrictions was a sharp break from the very limited franchise linked to communal identities and property qualifications that had been provided through various colonial reforms. And yet, somehow, improbably, it has worked. As Day says, the Indian Constitution profoundly transformed everyday life in the Indian Republic. And this process was led by some of India's most marginalized citizens rather than by elite politicians and judges. The Indian adult populace, one that had never before in history known that such a thing could be, rapidly cottoned on to the power it now had in its hands. If there is one lesson politicians in post-independent India have learnt, and learnt the hard way, it is never to take our electorate for granted. And that is why our elections are so spectacular. Consider this. India going to the polls is like all of North America and all of Europe going to the polls simultaneously. So let me ask straight away, what could conceivably be more terrifying to a politician or his party than the knowledge that his or her continued political existence is every so often in the hands of the great unwashed? As the noise increases, more dissents, more raucousness, so too does the government's anxiety. By the way, I'm going to digress slightly here to suggest that it is now time to make a conscious change to our vocabulary. Because of this constitutional idea of India and this structure, it is time we now stop speaking of the ruling party or rulers. India has no rulers. India is not ruled, and so long as the constitution exists, it never will be. It may be governed for a limited period of time, but never rule. The sooner we rid ourselves of this colonial linguistic baggage, the better. By constitutional decree and even otherwise, power is fragile. This inbuilt fragility, this temporality of power and the risk of its interruption is a threat to every government. That choice of government and the power to append the term in office of a particular government speaks directly to the concept of choice. That, in turn, is logically and inextricably connected to the freedoms and liberties we find in Part 3 of the Constitution. For no one can be expected to make an intelligent electoral decision unless that choice is an informed choice. This necessarily requires the safeguards and guarantees of liberty, and it requires them to be constitutionally protected. If we invert the paradigm, we see the importance and the linkage. If we merely have the freedom to choose without the right to act on that freedom, then the freedom of choice is an empty promise. To put it even more bluntly, perhaps in a phrasing no government will like, the right to choose one's own government is an express recognition of the right to disagree with the present government. It is the right to dissent, but it goes further. It is the right to disavow the government and to deny it altogether any legitimacy to continue. And this is not just a right. Because it is tied to universal franchise, the constitutional ideal compels us every 5 years to choose. The right becomes a duty. Inherent in the breadth and openness of this remarkable constitutional ideal and the corresponding freedoms and liberties is an unsettling and uncomfortable unpredictability of result. This is why there are calls, even from within the voting populace, to limit available choices. We should, one argument goes, amend the Constitution so that only those with specified education can stand for election. No one has yet quite dared to go so far as saying that only the educated or the privileged should be entitled to vote, but I expect the day is not far when that too might be propounded. Successive dispensations seek to circumvent this perceived threat by different means. Dynastic succession, for instance, is an attempt to limit people's options and curtail the freedom of choice. If you cannot vote for the father or the mother, vote for the son. Other methods are more invidious. These are not peculiar to India, but India is also not immune to them. 5 strategies, by my count, in particular have gained currency, and not just here, but wherever across the globe, governments perceive themselves to be under threat. It is equally true, as commentators have said in the recent past, of governments from South America to Eastern Europe, all with claims to being under one form or another of constitutionalism. The first self-preservation strategy is to criminalize dissent and disagreement altogether. This takes many forms. The deployment of harsh criminal and anti-terror statutes beyond their avowed purpose, and, where it still exists, the invocation of sedition law. The latter has been much criticized. A.G. Nurani, whom I regard as one of our finest legal minds and a jurist of exceptional acuity and precision, has written extensively on the subject. More recent are the writings of Dr. Abhinav Chandrachud, a very fine lawyer in my court and one who somehow finds the time to straddle the two worlds of a busy practice and studied academic writing. Whether it is in the context of a protest or the cheering of this or that team in a cricket match, their trenchant commentaries argue that the law on sedition is outdated and out of step with fundamental constitutional concepts of liberty and freedom. A second approach is to weaponize ordinary laws, such as, for instance, taxation laws. These are openly used as threats to muzzle disagreement and dissent, and to ensure that a contrary voice remains unheard. Withstanding or confronting these attempts demands great resilience and, yes, a formidable financial and legal arsenal. The third tactic is to entirely trivialize the disagreement, opposition, or dissent, even when it takes a widely visible form. This is actually very effective. The protest is often a physical disruption of everyday activity, blocking a road or from the substance of their disputes. This endeavor is considerably assisted when those who support the dissenters and protesters manage to get it wrong on facts or law or both. A recent example was the consternation expressed about the farmers' bills by one commentator, a journalist with an otherwise stellar track record, but with evidently no familiarity with statutes. He wrote a piece critiquing the bills and led with what he considered its most shocking provision, the bar of jurisdiction of civil courts. He conveyed that this was an egregious statutory provision that did not exist in any other law. As any law student will tell you, it is not, and such provisions have received judicial interpretations for over 50 years. It is this kind of wrong-headedness that feeds neatly into all attempts at marginalizing dissent. The next step is to promote an entirely faux nationalism based on religion or ethnicity, and to warp the concept of nationalism to a purpose never intended by our Constitution. Manan Ahmad Asif, Associate Professor of History at Columbia University, has a challenging thesis in his recent work, The Loss of Hindustan. He argues that the shared political history of the subcontinent is reflected in the works of native historians from about 1000 CE to 1900 CE. That understanding of Hindustan, the idea of Hindustan, he says, was expressly of a multicultural, multi-denominational home. The most complete idea of Hindustan, he writes, came in the early 17th century from the Deccan historian Firishta. It inspired countless influential European thinkers from Voltaire to Gibbon. Yet somehow his notions of a multicultural Hindustan got lost and were replaced with a religiously divided subcontinent, one that is entirely at odds with its own history. As Dr. Rabindranath Thapar has been pointing out recently, both in her book on dissent and a series of lectures that followed, dissent and disagreement can be traced to our history and historical traditions. But let me return to these attempts that are being made by governments in power. The most recent of these attempts to muzzle dissent is also perhaps the most innovative, and it comes from a surprising quarter. Last week, a serving bureaucrat said that the new frontiers of war, something he called fourth generation warfare, is, hold your breath, civil society. Specifically, civil society can be subverted, can be suborned, these are his words, not mine, can be divided, and can be manipulated to hurt the interests of a nation. And he said this to the police at a graduation ceremony, exhorting them to see that they, meaning civil society, stand fully protected. This comment received stinging rebukes from a former IS officer and a former IPS officer, each of the greatest renown. Both pointed out that their mandates and their oaths were to safeguard the values of the Constitution. Both decried this attempt to turn the full brunt of the police on the very people the police are meant to serve and protect. As one of the critics also pointed out, the term civil society was itself unclear. I confess I myself have no idea what it means, if anything. What is a civil society? And as opposed to what? An uncivil society? where everyone is perennially rude? Is this a civil society as opposed to a criminal society? And what might that be? The mafia? A criminal society poses no threat, but a civil society does. And who is or is not a member of civil society? Journalists, historians, builders, handcart pullers? Does it include the police itself? How about bureaucrats, IAS officers, ministers, and judges? Yes, let's not forget judges. Are they civil society? Are judges a threat to the government? None of this is a local issue peculiar to India. Surveying autocrats across the globe, Anne Applebaum says this in her superb essay for the December 2021 issue of The Atlantic. If the 20th century was the story of a slow, uneven struggle, ending with the victory of liberal democracy over other ideologies, communism, fascism, virulent nationalism, the 21st century is so far a story of the reverse. I said none of this is new. Adam Zamowski, whose books range from Chopin to Napoleon and Poland, has a spectacularly incisive volume called Phantom Terror, The Threat of Revolution and the Repression of Liberty, 1789 to 1848. He uses a historical analysis to argue and identify the basis of the paranoia that created modern state policing and generated contemporary societies threatened by subversive forces. I would have liked to quote from this at some length, but I do not think time will permit it, so this much must suffice. In their terror of the French Revolution, the ruling classes of Europe saw conspiracy everywhere. Monarchs, aristocrats, and politicians, including Napoleon, set up formidable police networks to flush out and destroy the supposed terrorist cells. But the swarms of spies and agents provocateurs they mobilized only fed the fear and led to the suppression of all dissent and the persecution of anyone whose attitude or even manner of dress aroused their wild suspicions. Ideas are dangerous. And as one popular graphic novel put it, ideas are also bulletproof. So is this constitutional idea of India. And its dangerousness, and the dangerousness inherent to the idea, is what takes us to attempts at censorship and suppression of thought, expression, and dissent. These are first acts of self-preservation by governments, but an intelligent and nimble government will use these to force broad spectrum illiberalism, especially in culture, art, and religion. Therefore, this should be familiar. Things fall apart. The center cannot hold. Mere anarchy is loosed upon the world. The best lack all conviction, while the worst are full of passionate intensity. That is, of course, Yeats in The Second Coming. There is a passage I return to again and again. It is from a book called Kindly Inquisitors by Jonathan Rauch, a senior fellow of governance studies at the Brookings Institution. A liberal society stands on the proposition that we should all take seriously the idea that we might be wrong. This means we must place no one, including ourselves, beyond the reach of criticism. It means that we must allow people to err, even where the error offends and upsets, as it often will. So what is the way forward? Where do we go from here? Do we have any defenses at all? Or is this idea, the constitutional idea of India, doom, and the rest only a matter of time. I see two beacons. One is familiar and well known, and perhaps from me predictable. To many, it is the last bastion or the final frontier, depending on your perspective. It is, of course, the judiciary. And it is at its doors that successive governments have always balked. The judiciary frightens a government seeking to cling to power like nothing else does. Our own history shows repeated attempts to weaken the judiciary, most especially during the emergency. And we are, again, by no means alone. From Turkey to Eastern Europe to South America and the United States, this is a tale with regional variations. Has our judiciary withstood attempts to cut it off at the knees? I must leave that for another day, not because I'm fearful of saying what must be said, but because I do believe this to be a complex and intricate issue, one that is too often papered over, too often oversimplified. It is not easily answered by pointing to this or that individual occurrence. It needs careful and detailed study and measured conclusions. So some other time, perhaps. But I do insist today that if we look back across the decades, we find that the judiciary has, in its own sometimes startling way, come through in defense of the idea of India. In the Indian Supreme Court and the Art of Democratic Positioning, an essay I believe to be the finest, despite its somewhat heavy-handed title, in the volume Unstable Constitutionalism, edited by Mark Tushnet and Madhav Khosla, Pratap Bhanu Mehta says this about our Supreme Court. The Supreme Court's behavior in exercise of jurisdiction and the form of arguments it deploys must be viewed in the context of a messy political democracy. It is an institution that must be mindful of the fact that it is competing with other branches of government for broader public legitimacy, and that its exercise of power is an intervention in an ongoing democratic discourse. Therefore, it will not often have the classic rule of law characteristics. Rather, it will be a messy compromise driven by competing concerns, values, and a sense of its own institutional possibilities. The court's role is more as conflict managers, and its interventions will be tailored to how it perceives it can best manage that conflict. He goes on to show how the Supreme Court acts as a custodian of what it perceives to be the public interest, and how it is driven by what he describes as an inchoate sense of what public opinion requires. This, he argues at some length, has both potential and pitfalls. The second bulwark comes from something we take for granted. It is surprising, but its power is very real and truly formidable. Technology, specifically the internet. For if there is today one thing that obliterates geographical boundaries and makes impossible the kind of censorship territoriality we saw in the 1950s in Ramesh Thapar versus State of Madras, a localized Madras ban on a Bombay-based publication, it is the internet. A fundamental truth about the internet is this: no government can shut it down, at least not completely, and not without risk of the government itself collapsing. Everything the government now does, from communication to finance, every single aspect of governance is now dependent on the internet. Big government and big business depend heavily on online communication. Perhaps perhaps they believe that, like the newspaper barons of the past, they could control it and therefore dictate what went forth and what did not. but it is nearly impossible to control or choke. That is partly why, over the past few months, I have had before me in court half a dozen so-called defamation cases, almost all of them by companies and businesses complaining of critical comments on YouTube and social media. Therefore, it does not matter today if someone in America speaks of 2 Indias or 10 or 29. Like the smog in our cities, the message will get through and will creep in even under the most solidly closed doors. If illiberalism is the biggest threat to a constitutional democracy, then the internet is the biggest threat to illiberalism. But with it has come something unprecedented in the last 2 years, something unknown in the history of mankind, and perhaps something good did come of the SARS-CoV-2 virus. I speak of the qualitative leap in access to justice, when now one can marry technology to the justice delivery system. It is futile to pretend any longer that online hearings or hybrid hearings are transitory things, or that we will soon return to our creaky, dusty, and expensive ways. It will not happen. More importantly, it should not be allowed to happen. For this, more than anything else in recent memory, has changed the face of the judicial system. So consider what happens when a judiciary with a strong sense of itself offers phone-in-hand access to the highest courts in the land. This much is clear. The counterpoint and the counter-narratives are now, thanks to technology, almost impossible to silence. There may be more adverse comment and more noisiness now than ever before. But is that not the point? Is that not what our Constitution contemplates or even demands when it says that the idea of India is embedded in these concepts of a union of states and of a constitutionally mandated choice to give any government its marching orders at a defined interval? In the constitutional scheme of things, there is simply no such thing as too much noise or too much dissent. If there is one thing the Constitution does not contemplate, it is the comfort of conformity or the tranquility of the familiar. The seed planted in the Constitution has taken hold. Attempts to uproot it have not succeeded yet. But we should not, I think, be too sanguine. As we have seen, there will be continued attempts by every government everywhere to maintain control, to transition from government to ruler. That is something we must guard against. To paraphrase what I wrote and what Daras mentioned, governments will come and governments will go, but the idea of India, the constitutional idea of India, resilient though it has proved to be, must be protected. Again, history will not judge us by our highways or bridges or statues. It will judge us by how well we have preserved this constitutional idea of India and saved it from being undermined. Thank you for listening.
Venkatesh, sir, you're muted.
Thank you, Justice Gautam Patel, for this fascinating talk. Many of us, would find it difficult to navigate the idea of India without touching the contemporary events. But you explained it very nicely in depth and without, naming the participants. That was really challenging. Can I request Justice Madhur Loku to respond to Justice Gautam Patel's lecture and also explain in his own way his idea of India?
Yeah, thank you, Mr. Venkateshan. Well, first of all, I must say that lecture given by Justice Gautam Patel was outstanding. It just covered just about everything about the idea of India. And really, I agree with him entirely. So there's not much that I can add to what he has said. In fact, if I try to add something, it might just take away from the outstanding lecture that he has given. That was really, really very good, Justice Patel. But I would like to just focus on two things, and I will be brief on that, not in the context of an idea of India, because like I said, I agree with what Justice Patel says, but two things that I would like to focus on. One is on human rights. We've not been giving importance to human rights as much as we should. And it has come out more starkly in the recent past. And the second is the independence of the judiciary. Again, we have talked about the independence of the judiciary, but I think recent events in the last maybe couple of years have shown that there are problems in dealing with the independence of the judiciary. On human rights, I would like to just focus on very briefly on the freedom of speech. There are a lot of other issues, freedom of religion, for example, freedom or the human right to have health. But I would just like to focus on speech for a few minutes. And what Justice Patel had mentioned about dissent. We are not taking kindly to dissent and disagreement. I mean, that is the essence of the freedom of speech. That is the essence of democracy. That's the essence of good governance, which Justice Patel was talking about. There are hundreds of cases that have been filed accusing persons of sedition. Nothing has happened in any of those cases, except that the persons who have been accused of sedition have spent time in jail unnecessarily, and it has had an impact on their future. I will give you one example, just one, of a young lady from Bangalore who came out with something called a toolkit, right? That was treated as sedition. She was brought from Bangalore to Delhi, put in jail for a couple of days, not allowed to contact her lawyer, and eventually she was granted bail. This lady is an environmentalist. She wanted to attend this COP26, which was held recently in Glasgow. She applied for a passport 3 months ago, and it was not processed. COP26 is over, everything is over. She still hasn't got her passport. At least she did not get it in time for COP26, so she could not attend. Now, look at it from the point of view of the victim of something which should not have happened. I mean, she should, in the first place, not have been put in for sedition, a very, very serious charge. And look at the consequence of that. I will not be surprised if a person who is accused of sedition manages to get a passport, applies for a visa, and the visa giving authority, whoever it is in the embassy or the High Commission, says that you are a person guilty of sedition or accused of sedition. I don't think I want you in my country. So there are long-term consequences of this. Now, unfortunately, what has been happening in the recent past is that from sedition, we have gone to UAPA, and the recent trend is the use of National Security Act, or in another part of the country, Public Safety Act. So people are just getting arrested day in and day out for something that they have not done as a crime. That is important. And that's where dissent comes in, which Justice Patel spoke about. Why can't you disagree with what has been said? Just because you happen to be the government, it doesn't mean that everything that you say is right. It can't be. The second is the right to assemble peacefully. Again, adverted to by Justice Patel. What was the allegation against the farmers? That they had blocked the highway. But when the barricades were lifted recently after the order passed by the, not the order, but by the speech given by the Honorable Prime Minister, we saw the barricades coming out. All of them had been put by the Delhi police, not by the farmers. So you had spikes, so you couldn't take a car over there or a tractor or whatever you wanted to take. You had, barbed wire, you had concrete blocks put by the state. And what did these people want to do? They wanted to come back last year. They wanted to enter Delhi and protest in Ramlila grounds where everybody protests. Okay, so this is another way of suppressing our democracy, our democratic human rights. Third, life and liberty. Wanton arrests that I've mentioned, searches and seizures. Oh, I have some information against you, so I'm going to come and search your house. I'm going to go and search your office. I'm going to hang around over there, for several hours. I'm going to seize your telephone. I'm going to seize your laptop. I'm going to take it away. And how you're going to function, I don't know. That's none of my business. So everything that is there in the laptop, everything that is there on the telephone is available and sometimes shared with friendly journalists so that it is announced on TV that this is what the WhatsApp chats are. This is what has come out of the telephone. Now, you have, these kind of things which are happening, which are troubling on the human rights front. Second, the independence of the judiciary. I don't know, like Justice Patel says, whether it's the last bastion or the final frontier. I don't know. But why is the judiciary not reacting to some of these situations? We talk about a person getting bail on Diwali or maybe a day or two before Diwali, and the Supreme Court saying that even one day's arrest is not good. But we have 69% people under trial. We have people in jail for years together, and in some cases almost a decade. Are they not entitled to bail? And they've been put in for something which they have done innocently, but which is interpreted wrongly. And it happened recently to some journalists in Tripura. You just cook up a case, put the person inside and say, well, that's it. And what does the judiciary do about it? Not much, I'm afraid. Transfers is another aspect. Professor Mohan Gopal has written a wonderful article, as only he can, in the Leaflet, published very recently, very well articulated, very well reasoned. He mentions about the night of the long knives, so to speak, 34 transfers of judges having taken place in the month of September. Was it necessary? Why have so many judges been transferred? I mean, do we have judges at the High Court level who are not good enough and therefore need to be transferred? Chief Justices are being transferred. They're being denied appointment in some high courts. It has happened to one very senior judge. My view is that the system that we have of transfer of Chief Justices, that the Chief Justice should be a judge from some other court, it's about time we give it up. It was decided many years ago, 40 years ago, because of certain situations that arose in a particular high court, that it would be best to have a Chief Justice from outside that high court. That situation does not exist. That was 20 years before the collegium system came. And now there are enough checks on a Chief Justice in terms of appointment and so on through the collegium system in the High Court and the collegium system in the Supreme Court. And of course now an overactive executive. So the transfer of Chief Justices, I think, has to be abolished. Third, how about introspecting? When we talk about the independence of the judiciary, isn't it time that the judiciary sits down to introspect? I would recommend that every 2 years there is a conference of Chief Justices. How about having one next year? Have a conference of Chief Justices, thrash out the problems, and there are many of them. We talk about pendency, vacancy, so on and so forth. These are only just two of them, but there are many, many more. And the judiciary, whether it's the last bastion or whether it's the final frontier, it has to stand up. And I would like, if you were to ask me what is my idea of India, I would say an independent judiciary is a must. And unless we have a judiciary that stands up, that speaks out, that introspects, plans, our constitution will just become another written document, which we will keep on discussing on 26th of November and perhaps on 26th of January. So these are just a few thoughts, that I thought I should share. Thank you very much and all the best.
Gauri? So, I think you're muted.
Yes, sir. I'm just reaching out to Prateek.
I'm here. Hi. Thank you, Gauri. And thank you, Mr. Venkatesan. Thank you, everyone. I'm here on behalf of the entire team at the Leaflet. You can see just two of them, but there are many more in the background who have worked incredibly hard for this, and and the response that we received right from the start has been very overwhelming right from the day that we announced this event. And thank you to all the attendees who have signed in. We have who have signed in today on this Zoom and all our other social media platforms elsewhere. I would like to begin by thanking Mr. Darius Khambata for the wonderful introduction that he gave to Justice Patel and Justice Lokur. The anecdotes were very intriguing and great to listen to. And I thank Justice Gautam Patel for the enlightening talk about Bharat. You painted a very colorful picture with your words and the mental image equating India to a patchwork quilt, which would stay with the audience for a very, very long time. And I'm sure, and to reiterate one of your most important points, India may be governed and not ruled. And then thank you to Justice Lokur for shedding light on the human rights violations that have been a pressing point of concern for all of us of late. The sad reality is that dissent and disagreement has not been taken too kindly of late, and especially for a media organization like us. And lastly, I thank the entire team of the Leaflet, Mr. Venkatesan, Ritu, Roshmi, Gauri, Paras, Shweta, Shiva, Almas, Vineet, Sabha, Hamza, and the dozens of supporters who back us all the time. And lastly, but most importantly, I thank Ms. Indra Jaising and Mr. Anand Grover, the co-founders, and our biggest strength, the biggest pillars who have been driving us, and two people who have seen India for the past several decades and have played an incredible role in the democracy that it is. So thank you, everyone, and keep supporting Leaflet. In terms of a few updates from us, we are coming up with a new website, which should be launched shortly in about a week or so, and a new mobile application. So we're trying to do as much as possible to give the best experience to our readers, coming up with interesting podcasts, so on and so forth. So please keep supporting us, keep contributing to us, and thank you again. Thanks, everyone.
Thank you. Thank you.
Thank you. Good night.